Power of the lawyer is in the uncertainty of the law, said by Jeremy Bentham, who lived under a common law legal system. However, to an extent, this quote is also applicable to the civil law legal system. But there are fundamental differences between common law and civil law, in their origins, in their development, and in their contemporary applicability. So, what are these differences, and how did they originate? Civil law is sometimes referred to as code law. This is due to the importance that this legal system assigns to codified statutes. And on the other hand, in common law legal traditions, case law, also known as precedent, is of primary importance. Precedent is a judicial verdict that has been established in a previous case. Thus, this is how judges in common law legal systems influence the development of the respective law. So in civil law, codified statutes form the basis of the law, whereas in common law, precedent forms the basis. However, this is putting it too bluntly. In order to properly understand both legal systems, we have to examine their historical origins. Civil law can be traced back a little bit further than common law. In 527, Emperor Justinian became emperor of the Eastern Roman Empire, also known as Byzantium. He wanted to reform the entire Roman legal system and ordered the creation of codes of law. This culminated in the Corpus Juris Civilis, compiled between 529 to 534. Many legal codes of European countries were based on these laws and then developed in their own way. This led to a variety of legal systems that still bore a lot of similarity. So on the European continent, customary law was making place for civil law. However, England went through a different development. King Henry II steered the English legal system in a direction that allowed him to consolidate his power. The Curia Regis, the local council, ordered judges to travel through England and record local customs and laws, aided by a committee of the local population, the jury. From local customs, a system of common law emerged, hence the name. There is a difference in the amount of weight a judge and the lawyer has in a civil law system and in a common law system. Because of the codification of law in civil law systems, judges are bound to the written law. In a sense, they are relegated to a comparatively minor role. A judge in a civil law system acts as an investigator. He initiates proceedings by bringing charges, he listens to and establishes facts through witness statements, and he applies the legal codes in order to wrap up the case. These judges do not create or formulate laws. They apply laws created and formulated by others according to procedures that the judges dictate. Interpretations of the law, and I am using this term very loosely, only occurs when a given law does not cover a case. Influence of judgments on the development of civil law therefore does exist, but it is much smaller than in common law. And lawyers in a civil law system, they represent the interests of their client, but their role is much less central than it would be in a common law system. Their function with common law lawyers does overlap when it comes to advising their client and with preparing legal pleadings for filing with the court. The distinction between common law lawyers and civil law lawyers becomes evident when you look at the importance of presentation, oral argumentation, and having to convince a jury. All these elements are central in a common law legal system. Furthermore, in the common law legal tradition, lawyers are tasked with examining witnesses, whereas in the civil law legal tradition, judges have this task. So what is the role of a judge in the common law tradition? In this legal system, people know who the judges are. A book I had to read for university describes common law judges as culture heroes. The legal tradition of common law systems has developed and grown in the hands of judges, case by case, slowly growing a body of law that binds successive judges through the doctrine of stare decisis. Stare decisis is the legal principle of determining points in litigation according to precedent. While there is an abundance of legislation, common law, to many, means law molded and created by judges. In common law, the judge not only functions as an arbiter, but he also has a greater flexibility to interpret the law and to find a solution for the case. And lawyers throughout the entire case maintain a very active role and attempt to convince the judge and jury. And lastly, in contrast to civil law, common law countries such as the United States prevent anyone from preparing legal documents except for fully licensed lawyers. So the history and influences of common law are customs united in a common law in England, and England exported this legal system to its former colonies. In civil law, the history and influences are based on Justinian law, Roman law. And Roman law is at the basis of comprehensive legal codes for various countries on the European continent. The main sources of law in common law are precedent, statutes and legislation. The main sources of law in civil law are codes and statutes. In common law, lawyers tread to the forefront and have to convince a jury, whereas in civil law, lawyers have a less central role. And in common law, the law is developed through precedent, so judicial verdicts. Judges slowly but surely create and mold law in these systems. Thank you very much for watching this video.